Good morning. Welcome to our annual meeting with the Bar. I do miss the days when we were all together in the Strom Auditorium, but I hope that meeting virtually allows for many more participants, and I know it is certainly more convenient for everyone. The good news is there is nothing earth-shattering to report today. No new electronic case filing system, no new COVID-related procedures and general orders, and no judge retirements. Rather, it feels like the past 12 months have been about holding steady and returning to normal just a little bit. For the purposes of today's meeting, the Q&A feature is enabled, so you are welcome to ask questions during the presentation. Several of our great clerk's office team are with me today and will answer questions as they come up. But please remember that your questions in the chat are visible to all participants. At the end of the presentation, you will be able to ask questions aloud, and I will do my best to respond. If I don't know the answer, I will find out what it is, and I will get back to you after the meeting or include it in the PowerPoint shared with everyone if it's pertinent to all attorneys in the district. Please remember that you are also welcome to send general questions throughout the year to the email address info@ganb.uscourts.gov. That is a monitored email address, and we do receive questions and respond accordingly. Of course, they shouldn't be case-specific questions, but general procedural questions or things about the website or something else that you would like for us to look into. You can, at the end of the meeting when we're doing the questions live, if you'll just use the raise your hand feature, then we will unmute your microphone and you can ask your question. Next week, we will post the recording of this meeting and the PowerPoint to the GANB website as we have done in the past. So you'll have a record of what's been discussed today. So with that, we'll move into, I forgot I'm controlling here, so let me move into the next slide. We'll move into statistics. So I've got statistics in two parts. One are the ones that are issued by the Administrative Office of the U.S. Courts for the 12-month period ending September 30, 2022. Georgia Northern is the fourth busiest bankruptcy court in the country, and of course, busiest is relative these days. They're not busy like we were back in 2010, but busy in the COVID era. 14,559 cases were filed in that 12-month period. We remain number one in Chapter 13 filings. The other courts in the top five are listed on the slide. It's Cal Central, which includes Los Angeles, and Illinois Northern, which includes Chicago, are generally duking it out for first and second place. Florida Middle, which is of course Tampa, Orlando, Jacksonville, and Georgia Northern, we sort of flip-flop between third and fourth. And then Michigan Eastern is bringing up the top five. Filings per 1,000, we rank 13th highest in the country at 2.02%. Alabama Middle ranks number one at 4.36%. For pro se litigants, we are 31st highest in the country, although maybe sometimes it feels like we should be higher, and that is 6.6% of our filings. Nationally, for the 12-month period, filings fell 11.7%. For Georgia Northern, for the same 12-month period, we actually were down only 0.1%. And that's a huge difference from what we've been experiencing over the past couple of years when our year-to-year figures were down 30% or more. The next slide are for the calendar year 2022, because we have seen some changes since January. So these are statistics for January 1 through December 31 of 2022, just for Georgia Northern. We are up in total filing 7%, which is significant for what we have been experiencing. You'll see the filing numbers for 2022. We had 12,474 filings, and in 2021, it was just over 11,600. Chapter 7s were down 13%. Chapter 13s were up 26%. That's typical for what we have seen happening in the country this year. During COVID, not surprisingly, Chapter 7s became the primary chapter of filing around the country, and certainly in Georgia Northern. We have sort of gotten back to our normal percentages, which 13s have generally been running about 55% of our filings, and we're back to that. Chapter 11s were up 4%, are up 4% for this calendar year so far. And we've had almost 50 Subchapter 5 cases filed this year. So I think we're all experiencing, and I think you would be able to tell me better what you're seeing in your offices, but we do feel that there is a significant change in what we're seeing in filings. Whether that persists for the rest of this year and into 2023, I think time will tell. But definitely there's been a sea change in the filings. We are in, of course, fiscal year 2023, and not surprisingly, we have no budget for the federal government. We are operating under a continuing resolution that expires at midnight on December 16th. With midterm elections coming up and potentially a change in one or both houses of Congress, it could be, and it's probably likely that there'll be another continuing resolution. And at least 1 year since I've been the clerk, there has been a full year CR. They never got to a budget. It was always operations under a CR. For judiciary, for federal judiciary, it's not that significant initially because we have funds at the national level. There are funds to continue court operations for a certain period of time, even if there is a partial government shutdown. So unlike executive agencies, which literally shut down, the federal judiciary continues normal operations for a certain period of time after a government shutdown. They tell us approximately 2 weeks, but it has gone longer than that in the past. And we are able to do that because we have funds other than appropriated funds from Congress, for example, filing fees. So bottom line, on December 17th, if there's no new CR or budget, we are open for business and there'll be no change for the foreseeable future. So I think the biggest topic that we wanted to address today has to do with virtual hearings. I asked the judges before today's presentation what messages they would like me to relate to the bar about anything. And it was sort of unanimous that they wanted me to talk about some best practices for virtual hearings. And just keep in mind, these come from the judges, not from me, which make it much more important. And we're glad that the courts around the country, and certainly our court, have been able to accommodate COVID-related issues in terms of appearing virtually, and now a lot more hybrid. But with that, there seems to have become a bit of a casual nature of how people are appearing, not just filers, but how attorneys are appearing. So here's what the court has asked me to share with you. Zoom hearings for court proceedings. I know you know this, but they should be treated and respected as court hearings. Do not do anything in a Zoom hearing that you would not do in a courtroom. I know that sounds basic, but I think it needs to be reiterated, and you should reiterate that to your clients, that Zoom hearings are court proceedings. There is a judge that's being recorded, officially recorded, and it needs to have everyone needs to have the demeanor on a Zoom hearing that they would have if they were in the courtroom here in the Russell Building or in Noonan Rome in Gainesville. Another best practice is to not interrupt. Now, the judges recognize that sometimes there is a delay in transmission. So you may think someone has finished answering a question or making a point to the court, and so you start speaking. But we just have to keep in mind that there is that delay. So it's okay to pause for a moment before beginning your presentation, or even asking the court, may I proceed, or some other way indicating that you want to speak before simply speaking. I don't know that any judge or many judges are using the raise the hand feature in the Zoom hearings. Maybe some of them are. And if so, that of course, that would be the way to do it. But thinking about it this way, if you were in an in-person hearing and you wanted to speak, you would rise and wait to be recognized, and the court would say proceed. So just be cognizant of the fact that there is this delay and you do not want to talk over each other. It's just harder to control that in a virtual hearing. The next tip, best practice, is to use headphones with a microphone whenever possible. That cuts down on echoes and any noises through the hearing, and it makes it a better experience for everyone. The next point is that a car is not an appropriate place to participate in a Zoom hearing as a lawyer or as a party. And this comment was based on real experiences, and I'm sure some of you may have had this happen, where a party was not calling from an office. They were not participating from an office, whether that was at home or in a their building. So just have to be aware of where you are participating and where your clients are participating in hearings. Also, backgrounds on your screens matter. Sometimes it's as simple as it's blurred or it's blank, and that's good. Sometimes you see far off wonderful places that people have traveled, or the beach, or children, or pets, and that can be distracting. Excuse me. So be sure that your background is muted, that it's not a distraction. Excuse me. Sorry. The next tip is appearances, physical appearances. So an attorney should dress for a Zoom hearing the way he or she would dress for a court appearance. And we have heard some really kind of remarkable examples of when that has not occurred. So just going back to the first point, that a Zoom hearing is a court proceeding, dress appropriately for a court proceeding, you as well as your client. Distance from the camera matters. Sometimes it's so close that it's distracting. Sometimes it's so far away the court can't really tell who's the person is who's speaking. So moderate your distance to the camera that you're using for participation as well as for your client. Excuse me. And also to make sure you read the notice in order that is issued by the court. Don't presume that a hearing is going to be virtual or that there's a virtual option. Sometimes the order and notice may actually say it's an in-person hearing. So don't make assumptions, read the notice in order and participate as you're permitted to. Know how to mute and unmute yourself on Zoom, and that sounds again basic, but it's very important. And if you don't know how to do it, you can ask your staff to help you or ask anyone under the age of 10, as I often have to do to use my electronics. They will show you how to mute and unmute. They'll also show you how to share your presentation. So sometimes there's a document that you want the court to see and you need to share that document. So be sure you know how to do that before the proceeding starts. And I think we'll wrap this section up, and you're welcome to ask questions either in the chat or at this point I'll say if you want to raise your hand and ask something aloud here, because this is such a critical part of what we're talking about today, you can do that as well. But the takeaway from this is that the failure to follow the best practices stated here by the court through me is that you may be required to appear in person. You may no longer have the option to appear virtually, even if other parties do. So please think about these things carefully. If you need clarification on anything, please feel free to call me, email, ask, but just know how important this is to the court. And these kind of practices will be monitored going forward. So I'll just pause for a minute and look at my folks in the room and say, does anyone have a question or a follow-up on this topic? Nope. All right, thank you very much. So we'll move off of virtual hearings and we'll talk about NextGen for just a minute. Fortunately, we're not talking about the migration to NextGen. That's done and has been in use now for over a year. And we thank you again for your cooperation in that significant undertaking. But we did have a couple of reminders. With NextGen came some significant changes on how attorney accounts are maintained. A lot of what we handled locally is now done only through Pacer. So first I will say the website address on this slide to our website that talks about NextGen of CMECF is full of information, practice aids, anything that should clarify questions that you have, which we would ask you to do before you contact the help desk. But one of the things that continues to be somewhat of an issue is updating ECF accounts. Those can, when it comes to address, phone number, email, that is done through Pacer. You make that request and then we get that via Pacer. You do not do that directly and we can't do it for you. So please just be aware of what you have to do through the Pacer Service Center. Also, if there's a change in employment or a law firm name, that is done through Pacer. However, we would ask you to contact the help desk for this first, because often we can make it an easier process for you, especially if it's a large global change. We can sort of direct and help you do that. It ultimately is done via Pacer, but we can maybe make that a little bit easier for you. And also remember, if a filing agent leaves your employment, you have to unlink them from your ECF account. On the website, on the NextGen page, is a job aid that will show you exactly how to link an agent and unlink an agent. And this is very important for your practice. So those are kind of the practice pointers for the CM-ECF NextGen migration that we've all been living with for a while. I hope that you found that to be was a relatively smooth transition and not too many problems going forward. Then we'll just talk generally about news and announcements, but as I generally do, I start off by saying if you have not signed up to receive the email updates that come from the court, the public notices, please do that. We use that almost exclusively now for sending out information about everything from NextGen being down for maintenance, to delays in court openings because of weather, to general orders that are issued, to changes in case assignments. Everything that is our source for news for you, and anyone can sign up for these. Attorneys, staff, the public, anyone can sign up for these. So if you go to our webpage, there's a box right in the middle of the section of the first page that says email updates. Click it, put in the email address or addresses that you want to use for these notices, and you will receive public notices as they are issued. So we had our usual good number of notices that went out, but not as many that were related to significant changes. I have a couple of them highlighted here, and these basically starting back from last year when about the time of the last meeting. And the first one is that in October of last year, we actually went cashless in the Atlanta division. We had already done that in Newnan, Rome, and Gainesville. So we accept payments now in Atlanta through money order, cashier's check, attorney check, but pay.gov is the payment method of choice. And that's for everyone. It's available for filers, it's available for attorneys. And we've gotten a tremendous amount of use from the pay.gov. So again, on our website, there's a tab that says payments, and it has all the information about pay.gov. There's a whole page on what you can pay and how you pay it. In December, on December 8th, 2021, we issued a public notice with a second amended and restated General Order 24-2018, and that was a new form of notice for voluntary notice procedures. And actually, this kind of came out from the last meeting in the bar. Someone asked a question about that notice not being exactly worded correctly based on the changes that had been made. So that general order and the form of notice was amended and restated. In January of this year, we introduced the Debtor Electronic Bankruptcy Noticing Program, DEBN, and I'm going to talk a little bit more about this one later. In August of this year, there was a notice regarding amended bankruptcy rule 2010 to reflect some changes in the Bankruptcy Threshold and Technical Correction Act implementation, a little bit technical, but important changes, and that was issued through a public notice. And again, in August of this year, we issued a public notice regarding changes to the reaffirmation agreement process, and was effective immediately that all reaffirmation hearings were done by Zoom, and that was for any case in any division. And I think that has really been a benefit to the parties, been helpful to the court. And so if you have questions or you haven't had to do a reaffirmation agreement in a couple of months, you may want to go back to the website and look at this public notice from August 11th that explains the changes. On August 15th of 2022, we did a public notice regarding the docketing of audio recordings. And this is not for all recordings or not all hearings. It's ones that judges designate. But the public notice has a job aid, and it will show you how you know if a particular hearing has been docketed and how to access it. So take a look at that August 15th, 2022 public notice, and you will see exactly how it works, and then you can listen to the hearing. That is, I do want to mention that is not the official, and that says this on the notice, but it's not the official recording. That is still done through the FTR product that we use in our courtrooms as the official recording of the hearing, but it's simply for convenience of the parties and to make things more readily available. In August was a busy month for us. In August of this year, we also introduced new unclaimed funds procedures and forms, and we've talked about unclaimed funds, I think, in prior meetings, but there's a tremendous amount of money at the federal level from bankruptcy courts all over the country for unclaimed funds. And over the last couple of years, there's been a real concerted effort to standardize the forms that are used by all 90 bankruptcy courts. And ours, we were kind of close to what they were doing, but we finally made the full change so that what we have is what has been recommended by the Bankruptcy Committee of the Judicial Conference and endorsed by the courts. So take a look at that. And also remember that on our website, there is what's called an unclaimed funds locator, and it pulls information from 40 or 50 bankruptcy courts that have unclaimed funds under different party names. And the product continues to be improved so that it's a more searchable product for all over the country. But you may have clients, both creditors and even debtor clients, that have money and unclaimed funds being held in this court or other courts. So take a look at that too. But you look at the forms because those have changed and it's a much easier process. And then probably our most important public notice of the last year was October 1, where we announced the new chief judge for the Northern District of Georgia, Chief Judge Barbara Ellis Monroe. So she has been on the job now for a while, and we are thrilled. I want to take just a minute to say that it also marked the end of a 5-year amazing term by Judge Hagenow as the chief judge. I cannot say enough about all she did for the court, for the clerk's office, for the bar in this district during a really trying time during COVID. So I'm happy for her. She graduated for being the chief judge, but we appreciate all she did for us. She was a tremendous chief. And just a couple of general reminders before we get into the federal forms and rule changes, and that is about flattening documents. I don't know that it's as big of a problem as we have had in the past, but just as a reminder, when you are preparing a document to upload in NextGen, flatten it. And that means instead of printing it to PDF, instead of saving it to PDF, you want to print it to PDF. That locks the document down. It's good for us, but it's really good for you because it prevents somebody from being able to change the document or view things that they should not be viewing. So if you don't remind your staff of that often, you should do that. That print to PDF is what you need to do to have a document flattened. Don't save it to PDF. And then I'll do my annual plug for our online procedures manual, which you can access from our website. It is in the process of being updated, so there'll be some more information coming about that in 2023. But if you haven't ever taken just a minute to go to the online procedures manual, I did it again last night because I think it's such a good document. And you just put in anything, say motions in bankruptcy. Every CM/ECF event, virtually every CM/ECF event that's a motion will come up. If you click it, motion to vacate. Not only does it have what it is, if there's a federal rule, it lists that. If there's a local rule, it lists that. It tells you step by step, click this, then that, choose that. It's a great training tool for new employees, but it's also an excellent reminder tool for people who do this work every day. So it's one of, I think, the best things we have done in my time as the clerk is the creation of this online procedure manual. And it's a living, breathing document that is regularly updated, but it's undergoing a pretty significant one now. So be on the lookout for more news about that in 2023. So with that, I'm going to stop for just a second and make sure there are no questions about any of the things we've discussed up to this point. We're good to proceed? Okay, thank you. So there are, as usual, some forms and rules changes effective December 1, 2022. And I've sort of put them in two categories in this presentation. The first are ones that do not deal with SBRA, and the ones that are just more generally applicable in the federal rules. So those are not as significant as in years past, but certainly there are one or two that we want to make sure you're aware of. So the first one is a change to Rule 3002, filing of a proof of claim or interest. And subsection C6 is amended to provide a single standard for granting motions for an extension of time to file a proof of claim, whether the creditor has a domestic or a foreign address. So if the notice for such creditor was, quote, insufficient under the circumstances to give the creditor a reasonable time to file a proof of claim, unquote, the court may grant an extension. Rule 5005, filing and transmittal of papers. Subsection B1 is amended to authorize the clerk or parties to transmit to the United States trustee by electronic means in accordance with Rule 9036, regardless of whether the UST is a registered user with the court's electronic filing system. In our case, of course, that's NextGen. Subdivision B2 is amended to recognize that parties meeting transmittal obligations to the United States trustee using the electronic filing system need not file a statement evidencing such a transmittal under Rule 5005B2. And it eliminates the need for that transmittal to be verified, of course, because it eliminates the need altogether. And this change to Rule 7004 is significant, I think. So 7004I is a new rule intended to reject those cases that interpret 7004B3 and 7004H to require service on a named officer, manager, general agent, or other agent rather than using titles. So service to corporations or partnerships, unincorporated associations, or insured depository institutions at a proper address can be to the attention of Chief Executive Officer, President, Officer for Receiving Service of Process, Managing Agent, General Agent, Officer, Agent for Receiving Service of Process, or other similar title. That those would be deemed sufficient under this amended rule, new rule 7004I. So in connection with this change, some of you may use, I think a number of you use the service manual that was originally authored by retired Judge James Massey, which has been updated and is posted on our website. That we have already made changes to incorporate this change in Rule 7004, but we won't release that updated manual until December the 1st when the rule change takes effect. And that service manual is located under Attorney tab, the Attorney Information tab on the website. And so I'm going to stop here and just give a general plug for our website. We really spend a lot of time making sure that what is on our website is the most current information and what we think is the most helpful information. So sometimes it's good to just go take a look at it. If you haven't looked around under the tab that says Attorney Information, the drop down will have a whole host of things that you may actually find useful, including a service manual. Some people may not know that this document even exists. So we just encourage you to look at the website, see what you can share with your staff that they might find helpful. For example, under the clerk's office, there's a drop-down menu that includes things like fees, the latest fee schedules, things like that. There's also a directory, and while it doesn't list all of the clerk's office staff, key personnel are listed and what their job title is. So sometimes if you feel like you can't get to somebody, if you dial the general number, you may find just the person you want if you go under the clerk's office directory tab and find the name and number for that person. So I just encourage you to make use of the website. Of course, if you find anything on there that's not up to date or is just wrong, we want to know that too. But we do have a team that looks at that regularly. So the last change that is not associated with the SBRA is under voluntary dismissal, and that's Rule 8023. And this amendment is intended to conform the rule to revised version of the appellate rule 42B on which it is modeled. It clarifies that the fees that must be paid are court fees and not attorney's fees. The rule does not alter the legal requirement governing the court's approval or settlement or payment or any other consideration, but it just conforms the rule to appellate rule 42B. So those are the rule changes that are not associated with the Small Business Reorganization Act of 2019, the SBRA. There are a number of these, and I'm not going to spend a whole lot of time going through them. I'm just going to kind of highlight them because you will see on the slides themselves a little more detail. And then, as we generally do after this meeting, we do a public notice that has a link to all the pending rules and form changes that will take effect December 1st. And that is maintained on the U.S. Court's website, and it gives you all the details. So that's your best source of information. We've sort of done a shorthanded version here for you, but we do want to let you know what is coming. So the SBRA rules did not go through the normal 2 or 3 year process that the Judicial Conference has for changing rules. These are much more quickly changed to adapt to this changing world of the SBRA, which came into effect in 2019. Rule 1007 amends subsection B5. It will exclude an exception to subchapter 5 cases. Because Code Section 1129A15 is inapplicable, there is no need for an individual debtor in a subchapter 5 case to file a statement of current monthly income. Subdivision H is amended to provide that the duty to file a supplemental schedule under the rule terminates upon confirmation of a plan in a subchapter 5 case, unless the plan is confirmed under 1191B, in which case terminates upon discharge. Rule 1020, Chapter 11 reorganization case for small business debtors. This rule is amended let me back up for a second. The rule is amended in response to the SBRA, that law that gives the small business debtor the option to elect to be a debtor under subchapter 5. And I'm going to apologize in advance if I say subchapter V and not subchapter 5. I hear people do that all the time, and I do it all the time too, and I'm really trying really hard not to make that mistake. It's subchapter 5. So Judge Bonifel especially, forgive me if I mess that up. The title in subsection A of the rule is amended to include the option for the election and to require a small business debtor to state in the voluntary petition or in a statement filed within 14 days after the order for relief is entered in an involuntary case, whether they elect to proceed under subchapter 5. And there are some other changes, but that's the main change here. Rule 2009, trustees for estates when joint administration is ordered. In a case that under that subchapter, 1183 of the code requires the United States trustee to appoint a trustee. So there will be no election. Accordingly, subdivisions A and B of the rule are amended to accept cases under subchapter 5. Rule 2012, substitution of trustee or successor trustee. Subdivision A of the rule is amended to include any case under that subchapter in which the debtor is removed as a debtor in possession under section 1185 of the code. Rule 2015, duty to keep records, make reports, and give notice of case for change of status. Subdivision B is amended to prescribe the duties of a debtor in possession, trustee, and debtor in a subchapter 5 case. Those cases are accepted from subdivision A because, unlike other chapter 11 cases, there will generally be both a trustee and a debtor in possession in the subchapter 5 case. Rule 3010, to avoid the undue cost and inconvenience of distributing small payments, the title and subdivision B are amended to include subchapter 5 cases in this rule. Rule 3011, unclaimed funds in cases under Chapter 7, Subchapter 5 of Chapter 11, Chapter 12, and Chapter 13. The rule is amended to include the Subchapter 5 cases because Section 347A of the Code applies to those cases. Rule 3014, election of 1111B by secured creditors in Chapter 9 or Chapter 11 reorganization case. Because there generally will not be a disclosure statement in a Subchapter 5 case, Section 1181B of the Code, the rule is amended to provide a deadline for making an election under 1111B in such cases that is set by the court. Rule 3016, Subdivision B of the rule is amended to reflect that under 1181B of the code, 1125 does not apply to subchapter 5 cases, and thus a disclosure statement is not required unless the court orders otherwise. Rule 3017.1, the title and section A of the rule are amended to cover such cases when the court orders that section 1125 of the code applies. This is a new rule, 3017.2, filing of dates by the court in subchapter 5 cases in which there is no disclosure statement. Because generally, as we've said, there will not be a disclosure statement in a subchapter 5 case, section 1181B of the code, the rule is added to authorize the court in such a case to act at a time other than when a disclosure statement is approved to certain times and dates. Rule 3018, subdivision A of the rule is amended to take account of the court's authority to set times under Rule 3017.1 and 3017.2 in small business cases and cases under Subchapter 5 of Chapter 11. Rule 3019, subdivision C is added to the rule to govern requests to modify a plan after confirmation in such cases under section 1193B or C of the code. So those are the rules that are related to the SBRA. We have 3 form changes that we want to mention. Related to Form 101, the voluntary petition for individuals filing for bankruptcy, the form is amended to eliminate the language in former Part 1, Question 4, which asks for, quote, any business names you have used in the last 8 years. Instead, Part 1, Question 2 adds this in this direction. Quote, any names that you have used in the last 8 years. So this will direct the debtor to include married names, maiden names, and, quote, any assumed trade names or doing business names, and to direct that the debtor should not include the names of separate legal entities that are not filing bankruptcy. And this is, they're hoping, will clarify some things that have been mistaken in the past when answering this particular questions about any other business names that may have been used. And then there are changes to Form 309E1, and that is the notice of Chapter 11 that goes out, and this is for individuals or joint debtors. And line 7, deadlines, is amended to clarify which deadline applies for filing complaints to deny the debtor a discharge, and which applies for filing complaints to seek to accept a particular debt. And a similar change is happening on 309E2, which is the Chapter 11 notice for individuals or debtors under Subchapter 5. So it's the same change. The form applies to regular Chapter 11s versus the Subchapter 5 cases. So those are the only form changes for this December 1st. So we're moving off of the federal rules and forms, and we'll go to a little commercial here for the DEBN, which is the Debtor Electronic Bankruptcy Noticing program. And again, that started earlier this year. We have a whole page on the website. If you click on it, it has all the information about what the product is, what the debtors receive, how to sign up for it, how to terminate from it if you no longer want to do that. But the bottom line is it's a way for debtors, both represented debtors and pro se debtors, to receive notices, court-issued notices via email rather than paper from the BNC, Bankruptcy Noticing Center. So, for example, things that are included on that list this is not universal list, but the notice of meeting of creditors, notice of deficiency, notice of hearings, order of discharge, orders on motions for relief, order of dismissal. Instead of getting mail on those, your clients or pro se parties can receive those directly using the DEBN program. The web page on this talks about what happens if, for example, an email address bounces back. We make sure that immediately that debtor, the BNC does it, they're automatically reinstated to paper mail. So there are all kind of safeguards in there to make sure that one way or another, by email or by paper, the parties or debtors are receiving the information they need to receive that are court generated. We started adding a notice to all new cases once they're filed that's served by the BNC, and it's a notice that lets the debtor know that there is this free electronic noticing program, and it tells them on the website, it shows them where they can go to click to sign up. And so we are seeing an increase in the folks that are using DEBN, but we encourage you to talk to your clients about this. We actually added some CBCF events, so to make it easier for represented parties, for their attorneys to sign up their clients through the electronic filing program. So it's a great service, it's a free service, and we think that in the long run it's the best communication method for debtors. So we just encourage you to look at it if you haven't, and to encourage your clients to use it. If you have any questions, please send an email to that info@ganb.uscourts.gov email, and we'll get an answer to you right away. I asked the United States trustee and the Chapter 13 trustees if they had any announcements that they wanted me to share. Probably the most common question for the U.S. trustee these days is, when will meeting of creditors go to Zoom? I think everyone is aware that there was already an announcement from the director of the executive office for United States trustees that 341s will remain virtual, and right now it's by phone, but they are underway rolling out the Zoom program throughout the country. Right now, Region 12 is the pilot for the program, but it will roll out eventually nationally. There is not a start date now for Region 21, which of course includes Georgia. But when that date is known, the U.S. trustee will share that information. The 13 trustees wanted me to let everyone know that all 3 of their offices will offer free online financial courses, both in English and in Spanish, for debtors to receive the financial management certificate. Melissa Davies' office is underway, it's live, and if you go to her website, which is on the site, it will, on the slide, it will tell you how your clients can obtain that financial management. You probably know this, but the trustees can only provide that for their debtors and cases to which they are assigned. So Melissa Davey can only provide this for cases where she's the trustee. Nancy Whaley's office will start offering this sometime in the next mid-December, I believe, and Ed Saphir's office is in the process, and they'll roll it out in hopefully early 2023. So within a short time, all trustees will be offering this free service to debtors to get their financial management certificates, which is a great service, and really happy that they're able to do this for everyone. Just a couple of general announcements. As we're moving into winter eventually, although it's, I think, 70 degrees outside today, WSB remains our official source where we release information about court closings or court delays. We also, of course, post it on our website. But if you are checking news and want to know if the court in any division is closed because of weather or delayed opening, WSB is where you would go for that, online or on TV. I think I already mentioned that the recording of this meeting and the PowerPoint will be posted to the website early next week. And I think that is all I have. I will stop again and ask with my folks here in the room with me, are there any questions we want to talk about, or if anyone online wants to raise their hand and be unmuted to ask a question, now would be the time to do that.
The question is, do the new SBA rules apply retroactively?
That's a good question, and I'm going to thank you. I don't know if you could make sure you could hear what the question was. Are the SBRA rules that we went over today, do they apply retroactively? And I am 99% sure, although I am looking, I believe they are not retroactive. But let me see if I can tell you that real quickly, and if not, I will add it to the slide before we post it. But that's a very good question, and I probably should have thought to include that when I was preparing these slides. I'm sorry, I can't easily put my hand on it. I think they are. I do believe they are not. That's a double negative, but they're not retroactive. But again, I will update the slide and say that specifically. So thank you for whoever asked that question. Tom, do you have a question?
Yes, thank you so much for the information. Just this may not be the appropriate time to ask it, but I was curious. I've been reading about the PACER access fees and, a variety of, I guess, litigation pending the concerning the charges. Are you aware of the current status of, or is there a place I can find the current status of what charges are actually going to be made for review of PACER files in the bankruptcy system?
Thank you for that question. I don't have a specific answer for you. I would direct you to the U.S. Court's website, as they might have the latest information about that. Just by way of background, there have been several lawsuits around the country involving PACER and PACER fees, coming up in a variety of contexts. But there was a recent settlement of a particular case where the U.S. Courts actually is paying a lot of money to settle that matter. There has been talk, and there is a bill pending, actually, and the name escapes me at the moment, but it is to offer free PACER to any party. And that also involves really the development of a new filing system, which is a huge undertaking and a monumental expense that, quite honestly, the money doesn't exist for the judiciary right now to do that. So we have not received any official notification from the administrative office or the judicial conference about what will change in terms of the fees that are authorized by the judicial conference, and they authorize everything from filing fees to PACER fees. So we may receive something soon about that, and I will make it public as soon as I receive it and I'm allowed to do it if there is such a restriction. But at this point, I think the best information would probably be available on the U.S. Court's website if there is a public announcement.
Thank you.
Thank you for that question. Well, I think we kept it about 45 minutes, which is what I generally go for. I really appreciate your time and attention. We will post the PowerPoint, and I will add the information about the SBRA amendments and if they are retroactive. And if I can find out anything helpful about the PACER litigation or what's happening on PACER fees, I will add that too. I just suspect that won't be available, but I will certainly give that a try. Okay. And on that, I will wish you all a great weekend and a very happy Thanksgiving to you and yours. And we look forward to seeing you again sometime soon. Take care, everybody.